going before me. Can you please open it? Thank you.
Yes.
Good morning.
Good morning.
Howdy. On the record, the family division on January 24, 2024, and we asked everybody to identify themselves for the court's record, beginning with the plaintiff and counsel. Can I ask everybody to identify themselves, please? Morning, Your Honor. I'm Heidi Ames for the plaintiff. My left. So Megan's hands up. And Your Honor.
Robert Tangway. Your Honor, if I may, I put in a motion. I object to Attorney Ames from being anything more than an advocate. She did not file an appearance. She said she would in the primary DV case, and according to court rules, she must file an appearance in this separate matter, and she has not, and she's also been notified of such.
All right, Attorney Ames. Yes, an appearance was filed after, I am being copied on pleadings, so to the extent that there's a belief that there is an appearance, I don't know that. I'm certainly happy for to do another appearance if that pleases Mr. Tangway, but there certainly is no reason why, as counsel that has been involved with this case from the filing, that I should not be present and participating.
I'm looking at the court's docket listing for today's hearing, which shows that Attorney Ames is named as counsel of record. So I am assuming that you filed an appearance. In looking through the file, I noticed that you filed numerous pleadings. Perhaps before you leave the courthouse today, to be abundantly clear, would you please file either a special limited appearance or a general appearance if you intend to remain counsel on the case?
Absolutely, Your Honor. I have no problem with that. Thank you.
Your Honor, if I may, she filed paperwork prior to that, so I would like my objection noted. She filed the request, which was not a motion, to have this brought without filing an appearance, and I actually have audio and the transcript where she said that she would file an appearance in December of 2023, and she did not.
Right.
And so,
Your objection is noted.
thank you, Your Honor.
So we're here on an extension. The extension was filed by the plaintiff in December. I've reviewed the request for the extension and I've reviewed the objection. We're here for a 30-minute hearing, so you'll each have approximately up to half the amount of time that's allotted for today. And so I'll start with the plaintiff on reasons why you think there is good cause to extend the domestic violence final order, and then I'll hear from Mr. Tangway with respect to his objections.
Your Honor, Mr. Tangway has taken objection to the fact of offers of proof in the past, so I am perfectly willing to have Mary come up to the stand and ask her the questions, or I am happy to present via offers of proof, but I know that.
Let me address that this way. Mr. Tangway, first of all, do you object to sworn offers of proof if I swear in Ms.
Your Honor, I'm actually going to be calling to the stand. She will be my first witness. The orders that you put in that are looking at are fraudulent, known, physically and mathematically impossible.
The question is whether you object to offers of proof.
At this point,
You certainly have a right of cross-examination.
okay. So I object to Heidi Ames proceeding as offers of proof, but I do not object to offers of proof. So my objection is that Heidi Ames is an appearance according to the Domestic Violence Court Protocol, and she is not allowed to participate in this hearing anything more than an advocate. I do not object to offers of proof, but I will be calling to the stand. I do have an issue with, as I put in the pleading, the court has not given me the reasons for the extension.
That's the purpose of today's hearing.
But you already granted the extension. This court did, Judge Chabot did.
That's the procedure under the statute and the protocols, and this hearing is to determine whether the extension will go forward. So that's why we're here.
Respectfully, Your Honor,
Yes.
I object on the record to that. This Law 173B extension states specifically that the court shall give reason or reasons. You've already granted the extension. The extension has been granted. It is in force. This is an objection hearing, and which I am going to prove that Attorney Ames and also Erica Andre have lied, known about the fraud physically.
All right. Okay.
So we will proceed.
Your objection is noted.
Thank you.
I'll allow Attorney Ames to proceed by a sworn offer of proof. I'll remind you both that we have 30 minutes and no party has requested additional time. So let's get started. Attorney Ames, would you please swear in your client for a sworn offer of proof?
Raise your right hand. Do you swear that the testimony that you are about to give or that will be given by offers of proof through your attorney will be the truth, the whole truth, and nothing but the truth? And do you swear that you will let me know if any statements that I make are incorrect, untruthful, and correct for record for the court?
I do. No, you may proceed. I just want you to be mindful of the time.
Absolutely.
Thank you.
Again, Your Honor, we have filed a request for an extension of the restraining order that was issued in December of 2022. Our reasons for that are outlined very explicitly to the extent that the court requires more specific testimony on that. My client is prepared to offer that, and I would like to give her a minute or two to be able to provide a statement to the court about the impact this has had and how she feels about it. But with respect to these offers, my client continues to be in fear for her safety and for the safety of her children. Mr. Tangway continues, even after the final parenting hearing, to escalate. No trespass order was issued against him by the Domestic Violence Coalition in Concord. That resulted in 2 police reports with a panic alarm being issued by the coalition because of Mr. Tangway's escalating anger and behavior in their hallway. Mr. Tangway went over to the YWCA after our hearing on September 5th, again, 2023, Your Honor. And the reason I know this is because he videotapes each and every one of these exchanges and posts them on YouTube, and so we are able to see firsthand the conversations that are had between him and the folks that he is talking to. They would not buzz him through the glass. He became visibly angry and upset. Again, he was asked to leave multiple times from the YWCA. So then he went to the coalition. He was asked to leave there.
Your Honor, objection, misleading. At this point, she's stating things that she does not know. Well, she does know that the fact that I was told to go to the YMCA. She has that in Supreme Court. I have an affidavit filed by my mother, so she does know that. So that is misleading, and I'd like to make that objection.
All right, your objection is noted.
Thank you, Your Honor.
Yes, thank you, Your Honor. In addition to that, Mr. Tangway frequently visits the Manchester Police Department to pursue criminal charges against my client for what he alleges was a kidnapping from more than 2 years ago. That happened before an incident that happened before the start of this case, where my client took the children camping in Massachusetts for a night. And from there, Mr. Tangway continues and has recently as November, gone to the Manchester Police Department to seek criminal charges against her, against her attorney, and against Judge Previtt in the court for his court orders. Mr. Tangway has gone to the New Hampshire Governor's office repeatedly, to the point where, again, he records these exchanges and he posts them on his YouTube, and he has been asked not to go
Objection, relevance. These are not relevant to the proceedings.
What's the relevancy?
It demonstrates his continued escalating anger and behavior with strangers, let alone with people he doesn't know and with agencies. This is what will happen if the restraining order is issued.
Your Honor, that is the government procedure. I'm a member of, I'm a registered lobbyist. I'm also involved in the court. I care passionately about law, justice, families, the environment, and she knows this. So my objection.
The objection is overruled, but noted.
Thank you.
The governor's office has requested he stop coming to the governor's office, or in the no trespass order will be issued against him there as well. He has gone to hearings where the executive director of the New Hampshire Domestic Violence Coalition is speaking, attempted to speak with her, attempted to videotape her. And so all of these things have happened since September 5th of 2023, which is when we had our final hearing.
Again, objection, relevance, Your Honor. Thank you.
This escalation of events continues to cause my client fear that as if the restraining order were issued, he would immediately resume the harassment and the abuse that he was pursuing and doing prior to the domestic violence, the final order of protection being issued. I'm happy to report to the court that since that order has been issued, Mr. Tangway has not emailed, he has not called, he has not texted, he has not, to her knowledge, shown up at her place of work or employment, and so the final order of protection is working. Prior to those things, as outlined in the court can take judicial notice of the allegations and the underlying petition, he would not leave when asked to leave her vehicle, her home. He was sending many text messages, making many phone calls per day for things unrelated to the children, and so my client is very fearful that this behavior will continue. Not only that, Mr. Tangway is much more angry now that final orders are in place and my client has been awarded sole decision making.
Objection, speculation. She's stating as to my mental state is saying that I'm angry.
I am, first of all, I have a
What's
video.
the basis for that statement?
The basis of the statement is he said it in his most recent video that he posted that he is angry. His exact words. And my basis for the statement is her fear. Yes.
Did you view the video?
Absolutely. I watch every video he
The
posts.
objection's overruled. May continue.
His anger is part of the reason my client is fearful. She does not know what he is going to do next and how he's going to escalate. My client would testify today that the person that Mr. Tangway is and how he acts in court and what he is doing outside of court, and again, posting videos of and happily filing the police reports and the no trespass orders with the New Hampshire Supreme Court. So we didn't have to go seek out these things. He is filing them as part of his pleadings in the Supreme Court. So he's acknowledging these things are happening, and those cause my client great concern. I'm mindful of the time, and so again, the standard for an extension of a restraining order isn't that there's a new incident of abuse, as the court knows. It's that there continues to be a fear for safety and outlining why there's good cause for why there's a fear for safety. My client would testify that she was afraid before she filed the domestic violence restraining order or the domestic violence petition. She's been afraid since then. She has altered her behavior. She has security cameras. She has changed her locks. She keeps her employment locked. The schools are on lockdown. She has had to change many things about her life because of the unpredictable behavior that we have seen here in the courtroom.
Objection, relevance. The schools are on lockdown. Has nothing to do with Ms.
We have seen, Your Honor, may I continue?
Yes.
Thank you. We have seen his behavior continue to escalate with third parties outside of this case. His anger is with the coalition right now. His anger is with the governor's office. His anger is with the courts. If this restraining order issued, my client has no doubt that that will be redirected towards her and the abuse will resume.
You mean if the extension is vacated?
Correct, that's what I meant, thank you. And so I want to offer her the opportunity to even speak for a minute, to explain to the court in her own words, as this was a complaint by Mr. Tangway, that I am speaking for her and that I am incorrectly putting words in her mouth, and I think it's important to give her 1 minute to say.
You're still under oath.
You don't have to read the whole thing, but it's just easier. I'll tell you.
How long is your statement now?
It's just like a page.
Okay.
Your Honor, I object that her statement has not been given to me if she's going to be reading from.
All I need you to do here, we're gonna close this. Tell the court why.
And I would like to note that the court that she is being directed by her attorney at this moment in time.
I'm happy to read words.
Let me rule on the objection. I think Mr. Tangway is correct. If there's a statement that's being read into the record, a copy ought to have been given to him. Nonetheless, I will allow Ms. Andre to speak.
Thank you.
Why she thinks that I should grant the extension. I'll give you a couple of minutes.
Thank you, Your Honor. Even with the DBO in place, Mr. Tangway has continued to abuse, harass, and control me any way he still can. It's through the legal system, withholding child support, and online articles, YouTube videos, and being on a podcast. He has filed over 70 motions within our cases and has taken both the parenting case and the DBO to the Supreme Court. More often than not, his motions he's filing are frivolous and repetitive. This has caused me a lot of stress, costs a lot of money, and he uses motions to continue to share his false narrative and make me look like a horrible person. He assumes a lot, but states it as truth. It's litigation abuse. He's not seen our kids in over a year and refuses to pay child support, knowing how difficult it is for me to maintain the household and support the kids all on my own. His behavior over this last year can be very erratic and concerning. Hearing the Domestic Violence Coalition had to file a no-contact order makes me really nervous. Mr. Tangway does not seem to understand boundaries, and what scares me the most is he's posting these videos on YouTube showing his concerning behavior, yet he doesn't see anything wrong with it, and acts shocked when people are in fear of him. He uses YouTube videos, podcasts, and online articles that are full of assumptions or false information to again portray me in bad light to the public, accusing me of kidnapping the children, fraud, perjury, and includes pictures of the kids and I. He spent months talking to the police trying to get me charged with kidnapping. All of this has been extremely hard and stressful on me. Knowing an email was sent out statewide to the domestic violence locations informing them of Robert Tangway's harassing behavior towards the coalition and other DV locations has caused me a lot of fear. Friends, family, my lawyer, police officers, and others have all been worried about my safety and well-being. Then to have an acquaintance at one of the DV locations call me personally because she was concerned with Mr. Tangway's behavior, and then reading Judge Previtt's notes explaining his inappropriate behavior in our final parenting order was confirming to me that I should be scared, and I need to continue to do what's best for the children and my well-being. I have been blocked on any social media, yet as soon as I started dating someone new, he was somehow aware of it and included it in one of his motions. It's been exhausting, constantly worrying. I carry pepper spray in one pocket and my keys in another. Wherever I go for my safety, the door to my work is locked and in between clients, and I've added extra security cameras to my phone because I'm scared of what he will do next. I believe the only reason he hasn't been in contact with me directly is because this protection order has been in place. I feel if the order is not renewed, the harassment will get even worse. Getting this protection order last year was not a tactic like Mr. Tangway believes. I got it because I was being harassed and scared of him, and I'm still being harassed and I'm still scared of him today, which is why I would like this order removed.
Thank you.
Your Honor,
Mr. Tangway.
yes, Your Honor, if I may, I would like to cross-examine the witness, but I'd also like to state that I did request more time, and I would like to know
You did request more time?
Of course I did.
When did you do that?
In the pleadings previous that were signed by
Which?
the
Do you
plead.
know the date?
They were in response and timely to my motion to continue. They were connected to the motion to continue.
So do you think you filed after December 29 when this hearing was scheduled and that was the date of the hearing notice?
Yes.
What was your pleading? Because I didn't see it and no extra time was allotted.
So that's, I came in yesterday and actually asked the court to see how much time, what the schedule was. So do you have a case after this at 9 o'clock?
Well, that's irrelevant.
I believe it's not, respectfully.
Well, it is. Did you file to ask for more
Your Honor, I would
than
not
30 minutes?
like to, yes, I did. I said that's not substantial time, and I actually asked that the court rule that this hearing, so
We're
it's,
going to do this, sir. There's been no request for additional time that I can see, and the hearing notice remains 30 minutes. You have the balance of the time, you may use it as you would like.
Okay, I'd like to hand over exhibits, and I object to that. I did file a notice, so I would like it to be.
If you could get me a copy of it, I'd like to see it.
You should have a copy. This is for.
Sir, when did you file it and what is it called?
It's called a notice. I don't know. I don't have that in front of me, and I feel that the court is wasting my time. Here is the exhibits, Your Honor.
Your Honor, I have not seen these exhibits, I do not know what they are.
Here they are. And again, I object to Heidi Ames et al.
You have
Being-
a continuing objection on that.
Thank you, Your Honor. So what the court has before them is a list of evidence.
Raise your right hand. Do you swear or affirm that the testimony you'll provide today will be the truth, the whole truth, and nothing but the truth, under the pains and penalties of perjury?
So help me God.
Thank you.
Miss Andre, if you look at Exhibit A, can you please describe what Exhibit A is?
Ms. Andre, I remind you, you're still under oath.
Yes. Your Honor, I'm gonna object to these exhibits, we've had absolutely no time to review them, I don't even know if I agree with many of the ones that are here. There says on the list a Christmas Eve email, I haven't had a chance to review that. I don't know what.
Your Honor, she has had a chance to review it. She submitted.
Sir, please don't interrupt when someone is speaking. Have you seen any of these documents before today?
So obviously, we have seen, Your Honor, the extension order.
Yeah.
How
How about number B, letter B?
B is the DD petition, so again, that's a pleading, so I don't have an objection to B. C, I absolutely object to, I don't know who Elecco is or what that.
Your Honor, I'm gonna object. She's seen this. This is
Sir,
submitted by her
I've
public.
asked you once, please don't interrupt while she's telling me what she's objecting to here. I'll give you a minute to respond. Go ahead, Attorney Ames. So you've
So we
seen
object to
A, you haven't seen B.
I haven't, just to be clear, Your Honor, these were not, he did not provide an exhibit list ahead of time, he did not let me know these were going to be provided as exhibits today.
I'm trying to understand if you've seen any of these.
The documents in general, I've seen A and B. D and E, I don't recognize except from seeing on a video.
C was submitted to the Supreme Court.
Sir, I'm not going to tell you again. Please sit down. Go ahead.
D and E were not submitted were not admitted as evidence at the family case. I do not know whether he included them as part of his exhibits, but all of his exhibits, because he didn't answer discovery, were not permitted to be part of the record.
Objection, she's lying. I did answer discovery.
You may continue.
Thank you, Your Honor. I don't know what F is, the DAW Internal Affairs Investigation. I have not seen anything related to that before. I know he's made allegations about it, but I have not seen any documents. I don't know what the Christmas Eve email is. I'm just gonna briefly take a look at it.
While she's not talking, Your Honor, I would like to state that for the record that you allowed her to hand over a written statement which she was not given. So in fairness of RSA 490D, this court must be fair. And then further, I would just like to ask her questions based on the things that she has.
Let me respond in this way.
Thank you, Your Honor.
I didn't take Ms. Andre's statement. You did. I don't have it before me. Secondly, the cover sheet that's attached to your documents, none of the documents are labeled A through I, and as I'm looking through them, they don't appear to correlate. So we're going to do it this way. I'm going to hear from you. You've been sworn in. You've reserved the right to cross-examine Ms. Andre. You may use the balance of your time as you may like.
Thank you, Your Honor. I appreciate that. Ms. Andre, looking at the domestic violence extension orders, Exhibit A, is everything on that document true? That is the document. That's the extension
Your
order
Honor,
before the.
what is the relevance of this in terms of the extension? Because he is back to the original domestic violence petition, the extension orders.
I think he's asking if the pleading that's attached is true. Is that what you're asking?
Your Honor, I'm asking, the extension order that is the extension order that was sent to the police and sent to me. That consists of 173B extensions. This court shall look at the original order
That's
and
the question for the
extensions.
witness.
Does she have a sliding glass door?
No, Your Honor. I have a back door with a big window in it.
Yeah, I'm asking you. So, knowing that on the extension order, that were granted, are those orders true and accurate?
Are the court's orders true and accurate?
Yes. And again,
My clients, I would object to this, my client's being asked in the moment to read a document.
Sustained.
Thank you.
Next question.
she filed, so she
Next
has,
question.
okay. Did I initiate 1,100 texts at any point during our communications in November, October, or September of 2022?
Sir, this is a matter that was litigated already. The question today is whether there's good cause to extend that order.
I'm going to object,
The
Your
finality of that order has been litigated.
Your Honor, I'm going to object. You're giving counsel to them. She's asked a direct question, and she was allowed to give her statement uninterrupted. I did not interrupt her. It's a simple question. We're here solely in your orders to discuss the petition which is attached to the orders. The court shall look at the orders and grant the petition, may grant an extension on the orders, which are what I'm asking her about, which she is known with counsel. And I would like to also state that Ms. Ames is not allowed to interrupt me constantly while I'm doing cross-examination.
Your Honor, I'm gonna object at this point. Again, today's hearing and the court made it very clear in its notice of hearing where it extended and provided Mr. Tangway the opportunity to have 3 additional weeks for this hearing, that the hearing was about the extension only. The underlying domestic violence petition was heard, it was appealed.
She
and
hasn't,
the-
objection, she hasn't stated her objection.
All right.
There's no grounds for objection, she's wasting my time.
Irrelevant. It is not relevant to the
next
instant
question.
proceedings.
I've already ruled on the issue.
It is exactly
What's
relevant.
your next question, sir?
She didn't answer my question.
Because I instructed her not to. We're not relitigating the domestic violence.
We're not, we're looking at the orders, which the court. So, did I initiate 1,100 texts at any point?
Again, objection, Your Honor. This is the
Okay,
same
Your
question.
Honor, withdrawn. Please describe the fear that you have of Robert Tangway physically hurting you.
You may answer that question.
Seeing the videos that he is posting, I feel his mental state at times is not he's angry at me, he thinks I'm lying, he thinks it's perjury. And seeing him in these videos, I am scared. I don't know what he would do. I don't know what he's going to do next. I don't know how much more he is going to escalate, and that's what scares me.
Okay. So, we're seeing these videos. You saw the governor at the governor's office, and you've stated, who wrote the petition, by the way? Who wrote the petition to the court? Was it you?
Your Honor, objection. Again, he's not clear about what petition he's asking for.
The petition for extension,
The extension?
yes?
Fair question, you may answer.
My lawyer filed the petition.
Okay, is everything true on that?
And the extension, yes.
Okay, and then everything's true in the orders?
Your Honor, this has been asked and answered. Again,
In what orders, sir?
In the orders for the extension?
if I may, Your Honor, if I can just indicate, Mr. Tangway is angry that the underlying petition said a sliding glass door. He doesn't deny praying at the door, he takes issue with the type of door.
Attorney Haynes, let's try to refocus here. I don't know how this witness can answer whether the court's orders are truthful.
She saw the court's orders and that she knows She has perjured herself. In a previous statement, the court's orders state that there's a sliding glass door, that I initiated 1,100 texts for 3 months, and that
Can you rephrase your question?
are the orders proper? I would like her to answer. Are they truthful? Does she have a sliding glass door, and did I initiate 1,100 texts?
Objection, Your Honor. Irrelevance, again, and asked and answered, and we've dealt with this question numerous times.
Your Honor, the court shall be guided by the law. You have taken an oath to, you are to follow the law, and so the court has to granted an extension based upon 173B. The original orders, they shall, which means you have no discretion via 1.2, shall look at the orders, and this is just a stall tactic, and I am going to ask that we have another hearing, because there is no hearing after this, and we can be here and figure this out. Your Honor, I desperately want to see my children.
Sir, you have a few minutes left, and you might want to use that time to make an argument to me as to why you don't think the extension should be granted.
The extension should not be granted because she just admitted that on the orders that she has no sliding glass door. She has not demonstrated any fear, and she also knew about this.
Knew about what?
I'd like to ask a question. Have you received all the pleadings that have been filed in the court cases?
Some of the Supreme Court ones I have not.
Okay, so in the parenting and also the domestic violence?
To my knowledge, yes.
Okay, so on those, they've stated Rule 311:6, attorney oath. Do you know that your attorney has the duty by court under pains of penalty of perjury to, excuse me, Miss Ames, you're standing up, to report any inaccuracies under penalty of pains of perjury? Do you understand that?
Your Honor, I would object. Mr. Tangway is asking if my clients have read the attorney's code of ethics, the attorney's rules of evidence, and she can answer whether she has read it or not. But again, I don't know.
Your Honor, they were
point
on
of
the
this
pleadings.
is.
Sustained. Next question.
Why didn't you correct the record?
Again, objection, Your Honor. This goes to the underlying petition that has been ruled on and held up by the Supreme Court.
Well, I'm going to sustain the objection for a different reason. I don't understand the question. Why didn't she correct what record?
Right now.
Do you understand the question, ma'am?
No, because you're.
Let me rephrase. Did you know, by reading the pleadings which you admitted, which state the law 311:6 attorney oath, that your attorney must report any inaccuracies under pains of penalty of perjury?
Again, Your Honor, I would object.
Overruled. You may answer the question.
No, I didn't clearly, thoroughly read the pleadings to that depth to know exactly the statement that you're talking about.
Okay. Now, has your mother ever loaned you money?
Your Honor, objection. What does a loan of money have to do with an extension of a restraining order?
Sustained.
Financial control. She states that there's financial control, Your Honor. I'm going to object to that. I would ask that she answer the question.
The objection is sustained, and sir, you have 1 more minute.
Okay. I am going to motion to continue this. I would also like to bring to the court's attention the reason why this, listen, I'm asking, you can do whatever you want, Your Honor. You can lie, cheat, steal. You can do that. I can do that. She can do that. I desperately want to see my children. This is inaccurate. You signed my orders and for denying me my petition for domestic violence, which 633:4
Sir,
interference
we're
with.
here on a very narrow, I'm sorry to interrupt you, but we're here on a very, very narrow issue. I'm not going to hear matters that are pending in other cases.
Well, it's not pending in other cases.
I've given you ample opportunity to tell me why you object to this extension.
I
I'll give you 1 more minute to finish your thought on that.
Because she's not in fear, she's demonstrated not in fear, and we just proved that she's lied on in her testimony today and in the past. And this hearing was specifically called, the court has not given me the reasons for granting the extension. Your Honor did not grant the extension, but she denied. And I'd also like to state respectfully, Your Honor, that according to the courtroom protocols, when I filed my extension, so this is why all the anger exists, because I am the victim. I am coming here by myself, isolated from society, and she ordered me, the court ordered me to violate the protection order by using our family wisdom to have direct communication. They did not change any of the orders. And if you look at the evidence that is submitted, the evidence submitted shows that other people have had to spend $22,000 to get their charges dropped at the Manchester Police for protection orders, which are fraudulent. They're abusing the system and abusing me and my children. And so I motioned the court to dismiss this because it was not filed by the attorney under
Yes.
any type of,
That argument, yeah.
thank you, and is physically and mathematically impossible. I have with the court,
I know that that's been your argument, I understand that.
right, the judge,
Anything else on an extension?
yes, the extension,
Today?
yes, Your Honor, 173B says specifically that the court shall extend it. You have extended it. Judge Chalbeau extended it and shall give the reasons for it. That's why this hearing is not sufficient for the matters that are before us.
All right, okay, I think I understand your argument. Okay, this hearing is adjourned. Thank you, I'll issue my order as soon as I can.
Please rise.
Thank you.